Bam! Welcome, everybody. Welcome to another glorious episode of The Branca Show. I am, of course, attorney Andrew Branca, and we're here today to talk about Tyler Robinson. Tyler Robinson, the man believed to have assassinated Charlie Kirk, being prosecuted for murder and a bunch of other charges, and facing capital punishment in this case. Now, this is in the news because a recent court filing in this prosecution made some waves when news media reported that the filing indicated the ATF was unable to match the bullet recovered from Charlie Kirk's body with the rifle authorities believe was used by Tyler Robinson to assassinate Kirk. The real story, of course, is considerably different than that clickbait headline. And indeed, the bullet rifle issue wasn't, even to my eye, the most informative or interesting part of that court filing. I will, of course, be covering this entire Tyler Robinson trial very closely. And in today's shows, I'll essentially do a kind of a kickoff of where everything currently stands, debunk a bunch of internet nonsense that's developed around this case, and step through that court filing that made these recent waves and explain it all to you, the legal realities, the truth in plain English, as, of course, is our practice here at The Branca Show and Law of Self-Defense. We're streaming in both places today because of the nature of today's content. All right, so let's start talking about this. So, of course, Tyler James Robinson. Well, let me make sure everything's working okay. So we should be on this live stream should be on YouTube, X. Let me make sure it's on X. And it is. Let me pin that. We're on YouTube, Rumble, X, and on the Law of Self-Defense website, which, of course, is my day job doing criminal defense and use of force legal analysis. So, a big spread today. So, Tyler James Robinson, a 22-year-old from Washington, Utah. He's from Utah, folks. Washington is the town in Utah. Has been charged by Utah prosecutors with assassinating Charlie Kirk, who was, of course, a conservative activist. The assassination occurred on September 10th, 2025, at Utah Valley University. Charlie was shot in the neck by a .30-06, which is a high-powered rifle, and, of course, killed essentially instantly. As a result, the person believed to have shot him is Tyler Robinson, who's now on trial. He's facing 10 felony counts, including aggravated murder, felony discharge of a firearm, obstruction of justice, witness tampering, victim tampering, enhancements, that the assassination was done for political motivation. That's part of the aggravating factors that gets you from a simple life sentence to capital punishment. And committing a violent offense in the presence of a child, because there were children present at the assassination. And as I said, prosecutors are seeking the death penalty. And seeking the death penalty, while it certainly doesn't seem inappropriate in this case, does greatly complicate the prosecutor's job. The standards for prosecuting a death penalty case are much, much greater than they are when you don't seek the death penalty. Now, the prosecution's evidence rests on a combination of, frankly, a lot of evidence. A lot of it's circumstantial, but a lot of evidence. Direct confessions by Tyler Robinson, forensic matches. They found his DNA on the rifle. Surveillance evidence. They have him on surveillance cameras. Motive. He wrote about his motive, how much he hated Charlie Kirk. These are all detailed in the charging documents. Maybe I'll go through the charging document as well. So direct confessions, written, texted, and verbal confessions. Some of these are currently just in a hearsay form. And I should mention the stage of the proceedings. We're not ready to go to trial. In fact, we've not yet done the preliminary hearing, which is a necessary gate you have to pass through to get to trial, a pre-trial proceeding. The court filing we're going to be talking about was a filing asking the court to delay the preliminary hearing, which is already 6 months. It was supposed to happen this month, in a couple of weeks, 6 months after the assassination, which is a long time before a preliminary hearing. But there's a lot of evidence in this case, so we'll get to that when we go through that court filing. So we have written, texted, verbal messages. We have forensics and physical evidence linking Robinson to the crime scene on surveillance images, linking him to the weapon. It was apparently his grandfather's rifle, as well as the DNA I mentioned, surveillance video, consistent timeline evidence. He was, had the means and opportunity to commit the crime. He had the motive to commit the crime, and motive's not an element per se of having assassinated someone, but of course it helps persuade juries beyond a reasonable doubt that he did it for political purposes, as I mentioned, is one of the aggravating factors that gets him to capital punishment. And there's quite a bit of consciousness of guilt evidence. That's what the obstruction and tampering with evidence charges are. The witness tampering are, he did things like tamper with evidence, which is classic consciousness of guilt evidence, indicating that not only does the state believe Tyler Robinson assassinated Charlie Kirk, but Tyler Robinson believes Tyler Robinson assassinated Charlie Kirk. Now, there is a lot of crazy talk on the internet about how this couldn't be Tyler Robinson responsible for this assassination. We're going to debunk some of that. The more concrete claim that, well, if Charlie Kirk was shot with a .30-06 bullets, and yet they recovered the bullet from his body, how can that be? It's a very high-powered cartridge. It's a 1,000-yard man-killing cartridge. Shouldn't it have blown clean through his neck? How was it that the bullet was retained in Charlie Kirk's body? That's impossible. This must all be a fraud. We'll debunk that because it's well documented. Many cases of high-powered rifle bullets being shot into human bodies and staying within the human body. It's not at all unusual. There's some people who believe that these text message confessions tied to Tyler Robinson were fabricated by other parties. Most of these conspiracy theories have to do with the notion that some third party other than Tyler Robinson actually committed the assassination. Of course, for the defense to make that argument, they have to have some actual evidence to support some third person having committed. You can't just speculate third party responsibility in a criminal trial. That's not permitted because, of course, every defense can do that. Every defense could say, hey, our client's one person. There's 8 billion people in the world. That's reasonable doubt that our client did it. No, you have to come forth with some substantive and material evidence to support the argument that some other person other than the defendant committed the killing. I've not seen any evidence like that yet. Now, there are things that the defense is beginning to raise, not so much as a defense, but in their court filing arguing that the preliminary hearing should be delayed. One of those is this inability so far of the ATF to match the bullet fragment found in Charlie's body to the rifle, a Mauser Model 98 .30-06 rifle, allegedly tied to Robinson because it was his grandfather's. I don't think there's much dispute about that. There's also complications around the DNA found on the rifle, on the towel that was accompanying the rifle that the state says matches the DNA of Tyler Robinson, but it wasn't much DNA. And because it wasn't much, special techniques were used to do the DNA analysis. In addition, there were other people's DNA also found on the rifle. So there's a mixture of different people's DNA. This led authorities to use a relatively novel, not necessarily robust analysis method for the DNA that could result in, I'm sure the defense will argue, incorrect conclusions. There's a ton of discovery, tens of thousands of pieces of discovery, and the defense is arguing that, listen, they just haven't had time to look through all of it. And of course, this is, as I said, a death penalty case. And one of the implications of that is it raises additional hurdles for the prosecution. We'll talk about those. But it also changes the dynamics for the defense. So Tyler, and I want to be careful about this because from the evidence I've seen, it certainly appears that Tyler Robinson is the person who assassinated Charlie Kirk. And we're all privileged to have kind of a common sense understanding and belief about what we think happened here. And of course, the loss of Charlie Kirk was terrible. I was in Las Vegas when this happened. I just got to my hotel, got off my motorcycle, my phone rang, and it was my wife calling me, crying, to let me know that Charlie Kirk had just been assassinated. She had been streaming the speech he was giving at the university when he was killed. She watched it live. So it's a very emotional and incident and a great loss, and it could only be called an act of outright evil. So we all have that kind of we're all privileged to have that kind of emotional take of things. But of course, you don't come here for emotional takes. You can go to there's other people on the internet who are happy to provide that. You come here for legal analysis, and so that's what I'm going to provide. Right, cold-hearted, emotionless, technical, legal analysis translated into plain English. And from the defense perspective, if you're the defense attorneys at Tyler Robinson, your client's facing the death penalty, the primary overarching mission is to not let him get assassinated. If he spends the rest of his life in prison and simply escapes execution, you've won that trial. That's victory in a death penalty case. Of course, you'd like more. You'd like to get him acquitted, found not guilty if you're the defense attorneys. But the primary objective is simply to not have him be executed. And one way to do that, to facilitate that goal, is simply to drag things out forever, right? If you could drag out the proceedings until Tyler Robinson dies of natural causes in prison, you've won. That's a victory for the defense in a death penalty case. So part of that dynamic is here, right? The defense is asking to delay the preliminary hearing, which of course will delay the trial, which delays everything, and the inevitable appeals that will follow a trial, especially a trial in a death penalty case. Everything gets stretched out in terms of time, and that's in the interest of the defense. It's not necessarily in the interest of justice. It's certainly not in the interest of the prosecution. And there is a value within the criminal justice system that involves not wasting resources, not wasting time getting to a final adjudication and a decision in the matter. And those are things that the judge, of course, will be balancing out. But while there are powerful incentives here for the defense to just stretch things out just for strategic purposes to keep their client alive, there is a lot of evidence in this case. I don't think the defense is being insane by saying, listen, we need more time. We haven't even gotten all the discovery that we're owed. We're supposed to have this preliminary hearing in a couple days. We're supposed to have the evidence and the opportunity to review the evidence. This is under U.S. constitutional law. This is under Utah constitutional law. This is under just rules of procedure in a criminal trial, especially a death penalty case when everything gets tightened up considerably. We're supposed to have all the evidence and time to critically review it before we even have a preliminary hearing. And we just haven't had that. So it wouldn't surprise me if the preliminary hearing gets pushed off here quite a bit. And maybe we should talk about some of the ways in which a death penalty case is more complicated. In fact, I think I'll invite my buddy Steve Gosney on for a future show to talk about all this. He's a national expert on death penalty matters. But just from my perspective, first of all, if you want to seek the death penalty, you have to give notice that you're seeking the death penalty, and they've done that. They've done that. In fact, I have that notice here. So, of course, the other side, the other party, the defense, is aware that you're going to attempt to have their client executed. That's, let's see, we don't need this. That's this document here. The state of Utah, through its county attorney, hereby gives notice of its intent to seek the death penalty for count 1, aggravated murder, as charged in the information. The information is what is used instead of a grand jury. It's a sworn statement by officials alleging the evidence and how it ties into the criminal charges. The decision to seek the death penalty is based on the available evidence and circumstances and nature of the crime. And they found that just shortly after Charlie Kirk was assassinated and Tyler Robinson was taken into custody. So they've met that burden. They've done the formal notification to seek the death penalty. Another complication for the prosecution is the jury selection process gets a lot more rigorous. For example, jurors are asked ahead of time, are you willing to sentence someone to death? Or do you have a moral objection to the death penalty that would never allow you to do that? For example, my friend attorney Steve Gosney, who I mentioned as a national expert on the death penalty, he has a powerful is not a strong enough word, opposition to the death penalty. I would expect he would tell us that he would never be able to sentence someone to death simply because of his Catholic beliefs and his moral position. He would not be able to serve on a jury in which the death penalty was on place. Also, the process through which you select the jury. Of course, we don't really select juries as attorneys. We have a modest ability to deselect individual jurors. We're largely stuck with the jury the community sends us. But in a death penalty case, the defense has a greater ability to deselect jurors than would otherwise be the case. Also, you kind of have two trials when you have a death penalty case, because you have, in a normal criminal trial, you would have the trial, the guilt phase of the trial, and if the defendant's found guilty beyond a reasonable doubt, he goes on to sentencing, and the sentencing is typically in the hands of the judge. There's a few states in which the jury plays a role in sentencing in non-death penalty cases, but the general rule is if it's a non-death penalty case, the judge determines the sentencing in accordance with sentencing guidelines and all that technical stuff. In a capital case, a death penalty case, you have the guilt phase of the trial. The person has to be found guilty beyond a reasonable doubt of whatever the charges are. And then you have a second trial. It's a sentencing trial because a judge himself alone cannot sentence someone to death. A jury has to make the decision unanimously to sentence someone to death. So the jury has to hear all those arguments and then vote on whether or not the death penalty should apply. So you have that separate penalty phase, kind of a mini trial that follows the guilt trial. You also have some heightened evidentiary burdens, both at the preliminary hearing stage, which is what we're looking at in this context, as well as at the trial itself. So, for example, for the death penalty to apply, there needs to be some aggravating factor. Here, the aggravating factor beyond straight-up murder is that it was done for political purposes. If you just wanted to convict Tyler Robinson of the murder of Charlie Kirk, you would not have to prove that aggravating factor at all. It wouldn't be an element in the case. It wouldn't be a charge in the case that you had to prove beyond a reasonable doubt. But if you want to seek the death penalty for Tyler Robinson, and obviously they do, then you have to prove that aggravating factor as well. It's an additional charge you have to prove beyond any reasonable doubt that otherwise wouldn't be on the table. And at the preliminary hearing stage, it's normal that at a preliminary hearing, the state can submit what would normally be inadmissible hearsay evidence, out-of-court statements being introduced for the truth of the statements themselves. You can't introduce hearsay in a trial unless you meet one of the admittedly many exceptions to the hearsay exclusion. But as a general matter, hearsay is not allowed. If someone made an out-of-court statement, you want to admit for the purpose of the truth of the statement, you normally have to bring that person into court. And the reason we have that rule is because there's an inherent unreliability to out-of-court statements made by, being presented in court by third parties, by people who didn't make the statement themselves, because then you can't subject the person who purportedly made the statement. They're not in court, right? Some third party is just repeating what they said. They're not in court to be questioned. And more important, they're not in court to be cross-examined. And if they're not available to be questioned and cross-examined, how's the jury supposed to make an assessment of the credibility of this out-of-court statement? It's inherently unreliable. It's just gossip. It's just rumor. So what we want you to do is not have somebody say, well, Tom told me this last week. Have Tom come in so he can be subject to direct and cross-examination in front of the jury. That's a trial. At a preliminary hearing, we relax those rules. Hearsay evidence can typically come in to a preliminary hearing. And the reason we allow that is there's no jury in a preliminary hearing. So there's no jury to make that credibility assessment anyway. And there's no risk of the jury being misled, being giving weight, excessive weight to a hearsay statement that we wouldn't want them to do, because as legal professionals, we recognize the inherent unreliability of an out-of-court statement, but a layperson might not. A lot of people make decisions based on gossip. We just don't want to allow that in a trial. In a preliminary hearing, which is what's coming up, we normally do allow hearsay evidence to be presented. That gets tightened up a lot when we're talking about a death penalty case, even at the preliminary hearing stage. So those are some of the additional burdens that a lot of prosecutors don't want to take death penalty cases, take on a death penalty case, or seek the death penalty in a case because of these additional burdens. It makes the prosecutor's job much more difficult. By the way, it also changes the appellant process. So normally, of course, most states have not all states, but most states have a three-level criminal judicial system. You have the trial court, then you have a mid-level court of appeals, then you have the state Supreme Court, and Utah has that too. But in a death penalty case, it's not uncommon, and they do this in Utah. If you get convicted at trial and you're facing the death penalty, you skip the mid-level appellate court entirely. Your death penalty appeal goes directly to the state Supreme Court, in this case, the Utah State Supreme Court. All right, let me take a look at, I've got a super chat. So, do you think you'll be able to cover the Carmelo Anthony trial starting June 1st? Are they going to televise it? I can't cover it if it's not televised. So it will, of course, be a state prosecution, not a federal prosecution. Federal trial courts almost invariably do not allow cameras in the courtroom. There are some rare exceptions. They're allowed to allow cameras in the courtroom, but generally they don't do it. State trials more likely to allow cameras, but they don't always allow cameras. And if they don't, then there's no practical way for me to cover the trial. I'd have to be in the courtroom, which is, whether you can get into the courtroom is questionable in the first place. But when I'm there, I'm obviously not able to live stream it. So we'll have to see what happens. I'll look into it and see. I've made a note to myself to check out whether they've already announced they're going to televise it. If they're going to televise it, I'll be. I would expect I'll be live streaming it for sure. Let's see. Do we have anything on Rumble? Kamikaze $5 says. Let me pull it up here so we can see it. He says there aren't any Rumble rants, but there's his. $5. Thank you very much, man. I appreciate that. Let me pull up, let's see. On the Law of Self-Defense website, where I'm also live streaming this. Let's see. It doesn't look like there's questions yet. All right. That's at lawofselfdefense.com, where you can learn to be hard to convict if you're ever compelled to defend yourself, your family, or your property. If that's of interest, and it should be, you may want to check out the lawofselfdefense.com webpage. See if I have a link for that I could throw up on the screen. So many. Well, I don't really at the moment. All right, so what are the factors? Well, let's go ahead and open up the this recent filing, or do we want to look at the information first? How long is the information? It's pretty long, but I think we should go through it. Because this is really the kind of the preliminary evidence that the state claims to possess that's consistent with Tyler Robinson's guilt. Of course, it is a document from the state. Their claims of guilt always sound good, right? A story always sounds good if you're only hearing one side of it. And of course, here we're only hitting one side, but let's go ahead and hit that side. All right, state of Utah versus Tyler Robinson. It's called an information. It's the equivalent of a grand jury indictment. It's a sworn statement by officials about the charges and the evidence they have to support the charges, to put you into the pipeline for a trial, subject to the various gates that have to be jumped through, one of which is the preliminary hearing that's supposed to happen in a couple of weeks, but I think is likely to be delayed. So the state of Utah charges the defendant Tyler Robinson with the following offenses. Count 1, aggravated murder. That on September 10th, Tyler James Robinson caused the death of Charlie Kirk. Conviction of this offense may carry the death penalty. Of course, we know they're pursuing the death penalty, or mandatory term of imprisonment for life without parole, or something not less than 25 years. Another charge, there's a victim targeting enhancement. That's how you get to the death penalty. Tyler James Robinson intentionally selected Charlie Kirk because of his belief or perception regarding Kirk's political expression. If a trier of fact, that would be the jury, finds beyond a reasonable doubt that this victim targeting enhancement applies, the sentencing judge shall consider the defendant's selection of the victim as an aggravating factor. Violent offense committed in the presence of a child, that's another aggravating factor for that count 1 of aggravated murder. That's how you get from murder to aggravated murder. Count 2, felony discharge of a firearm causing serious bodily injury. They're obviously just going to hit him with everything. Again, we get a victim targeting enhancement here, and in the presence of a child. Count 3, obstruction of justice. That Robinson, with intent to hinder, delay, or prevent the investigation, apprehension, prosecution, etc., of any person regarding their criminal offense, concealed or removed the firearm used to shoot Charlie Kirk. And the conduct that constitutes an offense would be a capital felony or first-degree felony. So it's obstruction in the case of a murder, an aggravated murder case. Count 4, obstruction of justice. Robinson, with intent to hinder, delay, etc., destroyed, concealed, or removed the clothing he wore during the shooting. Count number 5, tampering with a witness. Robinson believed an official proceeding or investigation was about to be initiated, the investigation of his killing of Charlie Kirk. Attempted to induce or otherwise cause his roommate, that would be his reportedly furry roommate, the biologically male roommate with which Tyler Robinson was reportedly in a romantic relationship, attempted to induce his roommate to withhold testimony, information, evidence that would be incriminating. Directing his roommate to delete incriminating text messages. That's also, of course, consciousness of guilt evidence. Count 6, another tampering with a witness charge. Attempted to induce his roommate to withhold testimony. Directing his roommate to stay silent if police question the roommate. Count 7, violent offense committed in the presence of a child. That's self-evident what that is. Probable cause statement by Brian Davis of the Utah State Bureau of Investigation. On September 10th, 2025, at approximately 12:23 p.m., Charlie Kirk was shot and killed while speaking to a large crowd on the campus of Utah Valley University in Orem, Utah. Police found the suspected murder weapon, a bolt-action .30-06 rifle, nearby. Over the next approximately 33 hours, they conducted a manhunt for the shooter until the evening of September 11th. The next day, Tyler Robinson surrendered to police. DNA consistent with Robinson was found on the rifle's trigger. After shooting Mr. Kirk, Robinson hid the gun, that's count 3, discarded the clothing, that's count 4, told his lover/roommate to delete incriminating text messages, that's the count 5 obstruction charge, and not to talk to witness tampering, and not to talk to police, count 6, witness tampering, and children were present, that's count 7. The shooting, let's see. Turning Point USA, that's Charlie Kirk's organization, of course. The event was announced far in advance, significant publicity. Several hundred people attended. At approximately noon, Mr. Kirk seated himself under a portable canopy. He began speaking to the crowd. a format Kirk used commonly at his events, fielding questions. Mr. Kirk's team members were very close to him. Let's see. What parts of this are really relevant? Approximately 15 minutes into the event, Mr. Kirk was answering a question about mass shootings by transgender individuals. How ironic. I actually didn't know that. When a gunshot rang out, the bullet struck Mr. Kirk in the neck. He slumped to the ground almost immediately. The bullet's trajectory passed closely to several other individuals beside Mr. Kirk. Children were visible near Mr. Kirk's stage when he was shot. Of course, this was all captured on video. He was rushed to a nearby hospital where he was declared dead. The medical examiner's report is pending as of the date of this information. A surveillance investigation. At the moment of the shot, a university police officer was watching the crowd from an elevated vantage point. As soon as he heard the shot, he began to scan the area for threats. Believing the shot came from a rifle because of its sound, he looked for potential sniper positions. He noted a roof approximately 160 yards away from Mr. Kirk as a potential shooting position and rushed there to look for evidence. The shooting position is adjacent to an open, publicly accessible walkway. A person must climb over a railing, then drop to the roof only slightly below. The officer climbed over the railing, down onto the roof. He walked to the suspected shooting position, confirmed a clear shooting corridor between the position and Mr. Kirk's seat. He also noticed markings on the gravel rooftop consistent with a sniper having lain on the roof, impressions in the gravel potentially left by elbows, knees, and feet of a person in a prone shooting position. Police reviewed surveillance from the camera covering the roof, discovered that it recorded an individual dressed in dark clothing crossing the railing, dropping onto the roof at approximately 12:15 p.m. Although the individual moved outside of the camera's view for a short time, the camera captured the individual running across the roof and then low crawling to the area the officer recognized as where the suspect had dropped into a prone shooting position. After a short time, which matches the known time of the shot, the individual arose and ran across the roof to the northeast. This discovery led to an intensive review of surveillance recordings. At approximately 11:51 a.m., the suspect entered the campus from the north, so this is on his way to the shooting position. He's seen wearing a black shirt with an American flag, a dark baseball cap, large sunglasses. He kept his head down and rarely raised his head enough to get a clear image of his face. He's seen walking with an unusual gait, very little bending in his right leg, consistent with a rifle being hidden in his pants. This unusual gait continues until he's seen crossing the railway and onto the roof where he leaves the camera's view. A camera later captures the suspect as he runs across the roof to the suspected shooting position. Immediately after the shot was fired, a camera captures the suspect running across the roof, carrying an item consistent in shape with a rifle. He can be seen climbing down from the roof. He drops the item he was carrying as he hits the ground in a controlled fall, picks up the item, runs northeast. Law enforcement officers followed the escape path to the northeast, where they believe the suspect had left campus, entered a wooded area. They found there a bolt-action rifle wrapped in a towel. The towel contained 1 spent round and 3 unspent rounds. So if you don't know, a bolt-action rifle, you work a bolt to chamber and eject rounds from the chamber, from an internal magazine in a Mauser. So you would load up the internal magazine, you push the bolt forward, it picks up a round from the magazine, puts it in the chamber. You fire that round. For that brass, then, that fired round to be ejected, you have to work the bolt. When you pull the bolt back, it ejects the round. If you push the bolt forward, it would pick up another round from the internal magazine. But if you don't work the bolt, the spent round's never ejected. So here, they're suggesting they found the rifle with the expended brass still in the chamber, which is why you wouldn't have found the brass at the shooting site. It left with the gun. As I note here, this is consistent with the facts officers observed at the time. Immediately after the shooting, no shell casings were found on the roof, suggesting a bolt action rather than an auto-loading weapon was used, and only a single round was fired. So if it had been an auto-loading weapon, That's a firearm that would have ejected and chambered a new round without needing to manually work a bolt. You fire, and the energy of the firing typically cycles the internal bolt of the gun automatically, ejects the spent brass. Then you might have expected to find a piece of brass on the roof, unless it would have been picked up, of course. Also, you would have found the rifle with a new round, a fresh round, chambered, not a spent round. Each round in the rifle contained an etched description, things like, "Hey, fascist, catch. If you read this, you're gay," stuff like that. This will be relevant because there were rounds, I believe, found at the house of Tyler Robinson with similar etchings. The rifle, ammunition rounds, and towel were sent for forensics processing, DNA consistent with Robinson's. That's not a match. Consistent does not mean match. So, for example, if the DNA, if all they were able to do, because there was relatively little DNA found, if all they were able to do was identify it as male DNA, but not an exact match to Robinson, well, Robinson's male. That would be DNA consistent with his, but not a definite identification. DNA consistent with Robinson's was found on the trigger, other parts of the rifle, the fired cartridge case, 2 of the 3 unfired cartridges, and on the towel. Law enforcement was unable to immediately locate the shooter, so they published photos of the shooter, asked for the public's help. Then the investigation ensues. On the evening of September 11th, law enforcement continued their investigation. Tyler Robinson went to the Washington County Sheriff's Office with his parents and a family friend who I believe was maybe a retired law enforcement officer, the family friend. Robinson's mother stated the following to police. This is evidence. So his parents said things that could be incriminating for him. By the way, there is spousal privilege. You cannot compel a spouse to testify against their spouse, but there's no parent-child privilege. On September 11th, 2025, the day after the shooting, Robinson's mother saw the photo of the shooter and thought it looked like her son. The mother called the son, asked him where he was. He said he was homesick and that he was homesick the previous day, the day that Kirk was shot. Robinson's mother expressed concern to her husband that the shooter looked like Robinson, and the father agreed. Robinson's mother explained that over the last year or so, Robinson had become more political and had started to lean more to the left, becoming more pro-gay and trans rights oriented. Robinson began to date his roommate, a biological male who was transitioning genders. This resulted in several discussions with family members, but especially between Robinson and his father, who have very different political views. In one conversation before the shooting, Robinson mentioned that Charlie Kirk would be holding an event at the university, which Robinson said was a stupid venue for the event. Robinson accused Kirk of spreading hate. Robinson's father reported that when his wife showed him the surveillance image, he agreed that it looked like their son, so now the father is making statements to police. He also believed that the rifle that police suspected the shooter used matched a rifle that was given to his son, Tyler Robinson, as a gift. As a result, the father contacted Robinson, asked him to send a photo of the rifle, I guess to show that it was still in his possession. Robinson did not respond. Robinson's father spoke on the phone with Robinson. Robinson implied that he planned to take his own life. Robinson's parents were able to convince him to meet at their home. There they discussed the situation. Robinson implied that he was the shooter. This would be a hearsay statement from the parents, right, in this context. And stated that but one of the exceptions to hearsay, by the way, to the hearsay exclusion principle, are statements against interest. Remember, the problem with hearsay is it's inherently unreliable because it's an out-of-court statement being recounted by someone in court, but not the person who made the statement. So you don't have the person who actually made the statement to testify. Here, of course, we have Robinson. But he's going to plead the fifth. Obviously, he's not going to say I said this. But a statement against interest is an exception to the hearsay exclusion rule because it overcomes that presumption of unreliability. You would not make a statement against interest unless it was true. Right? You would not hurt yourself with lies. So the father might well be allowed to recount this out-of-court statement for the truth of the statement, which would normally be inadmissible hearsay because it's a statement made by Robinson against his own interest. As they discussed the situation, Robinson implied he was the shooter, stated he couldn't go to jail, just wanted to end it. When asked why he did it, Robinson explained that there's too much evil and Charlie Kirk spreads too much hate. They talked about Robinson turning himself in, convinced him to speak with a family friend who's a retired deputy sheriff. The family friend met with Robinson and his parents and convinced Robinson to turn himself in. I wonder if the parents were aware that their son would be looking at the death penalty and if they would have made different decisions if they knew their son would be subject to the death penalty. The family friend spoke to police, reported telling Robinson it would be best if he brought all the evidence with him to the sheriff's office to avoid police having to search his parents' home. The family friend also asked Robinson if he had any clothes that were related to what he did, and Robinson said he had disposed of the clothes in different areas. That's part of the tampering with evidence charge. Police interviewed Robinson's roommate, a biological male who was involved in a romantic relationship with Robinson. The roommate told police the roommate received messages from Robinson about the shooting and provided those messages to police. On September 10th, the roommate received a text message from Robinson which said, "Drop what you're doing and look under my keyboard." Under the keyboard was a note that said, "I had the opportunity to take out Charlie Kirk. I'm going to take it." That's not good. The following text exchange then took place between Robinson and the roommates. Let's see. Roommate said, "What? You're joking, right?" And Robinson replies, "I'm not going to read all of this, but shouldn't be long until I can come home, but I got to grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I'm sorry to involve you. You weren't the one who did it, right?" "I am. I'm sorry." Let's see. "I had enough of his hatred." "Why did you do it?" "Why did you do it?" "Why did I do it?" "Yeah. I had enough of his hatred. Some hate can't be negotiated out. If I am able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything about them finding it." But of course, they had found it. "How long have you been planning this?" "A bit over a week." Let's see. "I believe I can get close to the rifle, but there's a squad car right by it. I think they already swept that spot. I'm wishing I had circled back and grabbed the rifle as soon as I got my vehicle. I'm worried what my old man would do if I didn't bring back Grandpa's rifle. I don't know if it had a serial number, but it wouldn't trace to me the serial number because it was a gift from his grandfather. So there would have been, no paperwork involved in the a technical legal transfer of the firearm. I worry about prints. I had to leave it in a bush where I changed outfits, didn't have the ability or time to bring it with. I might have to abandon it. I hope they don't find prints. How the F will I explain losing the rifle to my old man? Only thing I left was the rifle wrapped in a towel, which is what they found. Remember how I was engraving bullets? The effing messages are mostly a big meme." Let's see. I think that was a $2,000 scope. And then Robinson, part of the evidence tampering, delete this exchange. My dad wants photos of the rifle. Since Trump got into office, my dad has been a pretty diehard MAGA. I'm going to turn myself in willingly. Let's see. Don't talk to the media. If any police ask you questions, ask for a lawyer and stay silent. And the prosecution's saying that's witness tampering there. Now, of course, the correct advice for the roommate is don't answer questions and ask for a lawyer, right? The roommate could theoretically be facing criminal liability if they don't mention it in this text exchange. But if the roommate and Robinson had previously had conversations about doing this, the state could argue that the roommate was an accessory, co-conspirator in some manner. By the way, the same could be true for the parents, right? So we've had recent cases in which children brought guns to schools and shot and killed people, and the parents got prosecuted for failing to secure those weapons away from the access of the child. Could that apply here? I think Robinson was an adult living elsewhere. Probably not. But would it surprise me if the parents didn't want to cooperate? Would it surprise me if a prosecutor made that threat to the parents? In which case, of course, they'd need to lawyer up, absent immunity. Immunity would also solve the roommate's problem, of course. I hear the roommate is cooperating with police. I don't know if he's been granted, use immunity for any testimony or not. If the roommate has a lawyer, the lawyer should be holding out for immunity before the roommate cooperates with anything. The search of Robinson's residence. Police executed a search warrant on Robinson's residence. During that search, they discovered a shell casing with etchings like the etchings found on the shells in the rifle. They go through the counts again. Aggravated murder, the shooting and killing of Charlie Kirk, felony discharge of a firearm, that he endangered other people in the bullet's path, reckless conduct, basically. And of course, the shot fired recklessly actually caused serious injury. In fact, it caused death to Charlie Kirk. Obstructing justice for removing and hiding the rifle, obstructing justice for removing and hiding his clothing, witness tampering, telling his roommate to delete their messages, witness tampering, telling the roommate not to answer police questions, and of course, there were children present. All this filed on September 6th, 2025. Let's see. Law of Self-Defense website. Stephen asks, your procedural breakdowns are interesting. You're not covering much that I, Stephen, didn't get in law school, but there's a big difference between focusing on contract law and focusing on criminal procedure. Yeah, that's for sure. Stephen, again, what about the old man who yelled, I did it, immediately after the shooting, was apprehended? I haven't heard anything about him. And a quick web search hasn't turned up anything about obstructing charges. I'm not sure what happened with him. I did skip over that. That was part of the text exchange with the roommate. The roommate says, I thought they caught the person. And Robinson says, no, they grabbed some crazy old dude, then interrogated someone in similar clothing. But I haven't checked on what happened with the old guy. Yeah, I would be pretty pissed if I were the police and the prosecutors about that. Let's see. Any Rumble rants? Nope. This is like a low super chat show. I'm not giving people, maybe I should ask. So what do you think about that information? What do you think about that information? Based solely on the information. In fact, maybe I'll do a poll on YouTube. That wouldn't be a bad thing to do. Based solely on information, charging documents. Guilty? Not guilty. I should say not yet guilty. All right, I put that up on YouTube. The YouTube chat has that. Stephen Frazier, always generous. Thank you, Stephen. Says, okay, I was a bit late. I appreciate that, my friend. And a super sticker came in from Me Mama. Thank you very much. I appreciate that. All right. Now let's take a look at this this motion by the defense, just filed on March 27th. So just about, a few days ago. And step through that. I'm not going to read the whole thing, but I've highlighted portions of it, which I thought were the, someone says the old guy got arrested and charged with something different. That's my recollection too. I just don't remember exactly what it was. Aaron Flemings, member for 6 months, says, I was at an appointment, gift membership to follow. Well, that's really nice. Thank you, Aaron's. That'll go to somebody in the chat, selected by YouTube. Flower fund, $5. That goes to my wife, Miss Emily's flowers that I buy her every week. Aaron Flemings just gifted a membership. Thank you, my friend. I really appreciate that. The memberships, this, of course, is an open access show. After this show, by the way, we'll go from the memberships. We'll go from the open access show to the the members only show for today, which is going to look at what the heck is going on with NATO. NATO. Trump suggests NATO's finished. At least America's out. And of course, without America, there is no NATO. That's what we're going to talk about in the members only show. Only 16 cents a day to be a member, folks. $5 a month to be a member. Get double the number of Branca shows. And the members are really what keep this going. YouTube doesn't allow us to make any ad revenue because they don't like me. They don't like my political takes. So it's the membership contributions are really what enable me to spend these hours with all of you. But right now, of course, we're in this Tyler Robinson breakdown. Bruce Wayne says, good info. $5. Thank you, Bruce. That's very kind of you. Autom Hesh, $5, says the bullet not matching the rifle stinks to high heaven. Well, that's not really the reality of what's going on with the bullet. We'll go through that in just a moment. And Cricket contributed five Andrew Branca Show memberships. So make sure you say thank you to Cricket if you just got awarded one of those in the chat. Let's see. Somebody just sent me a news story. Yeah, I'll take a look at that after because it is off topic. I don't want to distract the show. I don't want to distract the show. Okay, that's the Law of Self-Defense members page. Whoops. Let me get to, I'm just looking for any questions or comments I might need to address. All right. Looks like we're all good. Oh, another Rumble rant. Let me pull this up. E. Morsk says, can you elaborate on how modern machining methods and science with a capital S, make it hard to match a gun to a bullet? And any cases on it, how firearm forensics is basically subjective in nature. I'm not going to have time to pull up, hard literature. A lot of what we call tool and die forensics work is fake science. It's hoax science. But yeah, I'll talk about that when I get to this issue in the defense motion about the ATF unable to determine a match with the rifle. Philip Coggins, $5, says the best thing about the bullet not matching is that maybe people will realize now that ballistics matching to a specific rifle is mainly junk science. Yeah, I agree with that. It's mainly junk science. Let's see. Let me pull up this motion and we'll start working our way through this. Whoops, that's not, where is it? Oh, here it is. We don't need that. Make this bigger. All right, so first, what is this? This is simply a request by the defense to provide them with more time before the preliminary hearing. They say vacate. Of course, they'd like the whole case to go away. But what they're really asking for is to continue or delay the upcoming preliminary hearing, pending more discovery, more receipt of discovery evidence from the state, and to permit constitutionally adequate, required, and reasonable time for preparation. And this is just a memorandum explaining their request. Mr. Robinson, the defendant, seeks to continue, or that's a legal phrase meaning to delay, the preliminary hearing scheduled for May next month to a setting and a time that allows him and his counsel to receive discovery necessary for preliminary preparations. Again, I'm not going to read this whole thing. I'll just hit the highlights. And that preparation is required by the U.S. Constitution, by the Utah Constitution, by statute, by criminal procedure. The defense is entitled to, raise an effective, right? You're entitled to effective counsel. For the counsel to be effective, they have to have an opportunity to review and critically review any evidence that may be presented against their client in court. And that's a lot of evidence. One of the main reasons they're asking for this delay. In total, the defense has received approximately 20,000 files, including digital electronics discovery provided on a hard drive on March 12th, which was not that long ago. Of these, the document and image files contain approximately 61,500 pages. The audio files are approximately 31 hours in total length. More than 5,000 video files contain more than 700 hours of video. So you folks probably know my day job is law of self-defense, criminal defense attorney, expertise in self-defense law. My legal practice is a consulting practice. I consult, provide my expertise to other lawyers, my clients or other lawyers who are lead counsel in defending their clients who are charged with some use of force offense. For me to provide an informed expert opinion on the viability and vulnerabilities of self-defense justification or defense of others justification or defense of property justification, I have to look at the evidence that's likely to be presented against their client in court. And often that evidence looks like this. Often it's an enormous quantity of evidence. And we don't take outside consults anymore. We only provide consults for our Law of Self-Defense Platinum members. But when we took outside consults, my normal retainer, my minimum retainer was $10,000 to consult on a case. And people say, well, that's a lot of money. I would suggest it's relative to the risks you're facing. Most of the cases I consult on are murder or manslaughter cases. So you're looking at spending much of the rest of your life in prison if you get convicted. And often we do get the charges dismissed without having to go to trial. So we do our job for $10,000. You save the multi-$100,000 of an expense of a full-blown trial. By the way, if you'd like to learn more about that, you can point your browser to lawofselfdefense.com/platinum, become a platinum member. If you're a platinum member, you get our consult for free. We don't charge for the consult. But the reason the consult was so expensive for non-members when we used to do consults for non-members was this: the sheer volume of evidence, every bit of which I have to examine in forming my expert opinion. It just takes a lot of time. And of course, for a lawyer, money is time. The digital electronic discovery received on March 12th amounts to approximately 12 terabytes of data and over 600,000 files. The initial review, not a critical review, but the first scan of the digital electronic discovery is anticipated to take 60 days to complete, after which time it can be determined if we even got the complete downloads or if additional time is necessary to attempt complete downloads. And I would suggest they would claim they need more time to do a critical examination, maybe hire experts to review this discovery. Defense experts, maybe somebody like me, except, of course, Tyler Robinson is not a platinum member of Law of Self-Defense and thus doesn't qualify for me to do a consult on this case. Not that this is a self-defense case anyway. The defense team has devoted and will continue to devote. I don't want to read everything here, just the highlighted portions. The Utah Court of Appeals identified a multi-factor test for assessing whether the denial of a motion to continue. So they're asking for more time before to put off the preliminary hearing. What happens if the court says no here? Well, that would be a denial of this motion to continue the preliminary hearing, and that would be appealed to the Utah Court of Appeals. And how would they examine this question? Would they decide the denial was legitimate? They look at a number of factors, whether other continuances have already been requested and granted. Did you already get more time? Is this just an abuse of the request for more time? Balancing the convenience or inconvenience to the litigants involved, the state and the defendant. Whether the requested delay is for legitimate reasons or whether it's instead dilatory, purposeful, or contrived. Whether the defendant contributed to the circumstances which give rise to the need for a continuance. In other words, did the defense do something wrong that caused the delay? or the need for a delay in the preliminary hearing, and whether denying the continuance will result in prejudice to the defendant's case, which of course they'll argue here. We won't have time to review the discovery unless we get the continuance. So the first of those factors, has there already been a continuance? There has not yet been. This is the first setting of the preliminary examination in this capital case. And of course, they're going to make a big deal out about the fact that this is a capital case, appropriately so, because it tightens up the protections for the defendant. It would induce the trial court to be more likely to agree to delay the preliminary hearing over the objection of the prosecution. On December 11th, the trial court they're speaking to, tentatively, in quotes, scheduled the preliminary hearing for the week of May 18th to 22nd at the request of the state. And the court said at the time, it is not set in stone. It can certainly be moved. If it needs to be changed, the court understands that. This is not a date that if we can't meet, there is any prejudice that will be attached. So it was a tentative date. Ms. Nestor, one of the defense attorneys here for Tyler Robinson, advised the court in December that it was likely premature to set a preliminary hearing, even one set 6 months later, and her warning was prescient. Notwithstanding the, I guess this is the prosecutor's office, best efforts, two law enforcement agencies, ATF, this would be the Utah County Attorney's Office. I'm sure that's what that stands for here. Despite the prosecutor's office apparent best efforts, two federal law enforcement agencies, ATF and FBI, and SBI, have not been able to produce discovery in time for the May 2026 preliminary hearing to occur. By the way, it's very common when stuff is sent to the ATF and FBI, they do their forensic analysis on their own schedule. It's very common for the defense and the prosecution and the state court to experience considerable frustration because they feel ATF and FBI are not producing the forensics results in a timely manner. Most common thing in the world. For ATF and FBI, once they get involved in the case, everything slows down. Hence, the court was also prescient in clearly stating the date as set was not set in stone and that no party would be prejudiced by the setting. The second factor for delay of the preliminary hearing, the balanced convenience and inconvenience to the litigants, witnesses, counsel, and the court. The defense argues there is no material inconvenience. This is just a preliminary hearing. It's still a few weeks out. It's not like people have already been flown into Utah to provide testimony. So they feel that factor is in favor of the defense request to delay the preliminary hearing. The third factor looks to whether there's a legitimate or contrived reason for the continuance. And of course, they say it's legitimate. The defendant has yet to receive appropriate discovery. He'll be denied his constitutional rights to effective assistance of counsel in preparing for and at the preliminary hearing if defense counsel is unable to investigate the evidence upon which the state intends to rely. And third, the discovery being requested is complex and requires more time than is presently afforded. And now they're going to talk about the law around this, and then they'll talk about the actual complexity of the evidence. So, some of the law about this. He has a fundamental right to critical review of the discovery, especially in a capital case. As related to evidence and discovery in anticipation of a preliminary hearing, which is a little different than for a trial, the Utah Constitution says nothing in this Constitution shall preclude the use of reliable hearsay evidence in any preliminary examination to determine probable cause that a crime has been committed. So hearsay evidence is allowed at a preliminary hearing where it might not be allowed at trial. If appropriate discovery is allowed, and of course the defense is going to argue, well, it's not yet been allowed. And the state is going to want to use that hearsay evidence, so we have to be given an opportunity to critically review it. A continuance is necessary to ensure Robinson receives the discovery to which he's constitutionally and statutorily entitled, and because under the U.S. Constitution, the providing of appropriate discovery is a precondition to the state introducing any hearsay reports. This is a legitimate reason to delay the preliminary hearing. So At trial, say the prosecution wants to submit a police investigation report at trial in front of the jury. They'll need the officer who prepared that report to come in, take the stand, and testify about the report. At the preliminary hearing, they can just present the report without the officer there to testify. That's why the report by itself, in the absence of the officer, would be hearsay evidence. Obviously, a report can't be subject to cross-examination. For example, you would need the officer there to be subject to cross-examination. The report alone would generally not be allowed at trial, but it generally would be allowed at the preliminary hearing without the officer testifying if the defense had the opportunity to critically review the report beforehand. And that opportunity is a requirement before the state could submit the report in a hearsay form to the preliminary hearing. The U.S. Supreme Court has also said that the most critical period of a criminal proceeding may be from the time of arraignment until the beginning of the trial, when consultation, thoroughgoing investigation, and preparation are vitally important. And I've discussed this with all of you before, too. We call them preliminary hearings, and it sounds like, well, they can't be very important, right? They happen before the trial. They're just preliminary. The phrase preliminary connotes something that's not of critical importance. But in fact, all these preliminary hearings are critically important. They define the legal battlefield for the trial. They determine the witnesses who will be presented or excluded, the evidence that will be presented or excluded, the expert testimony, the forensics, all the things that will end up in the trial or be excluded from the trial. All those decisions are being made now. In fact, in the trial itself, there ought to be no surprises for either party. Every party should know, the prosecution and the defense, exactly what legal arguments are going to be made and exactly what evidence is going to be permitted, exactly what the witnesses are going to say, although there's always a risk that a witness goes off the rails. They should know exactly what the reports are going to be. There shouldn't be any surprises in the trial because that all gets fleshed out before the trial in these preliminary hearings. Now, everything presented at the trial is new to the jury, but it shouldn't be new to anybody else involved in the proceedings. The Utah Supreme Court has acknowledged that a preliminary hearing is a critical stage at which the constitutional right to counsel attaches, and that means effective counsel. For counsel to be effective, to be able to effectively vindicate the defendant's rights, at minimum, counsel must be provided with the evidence against his client and reasonable opportunities to investigate and prepare for the preliminary hearing. The Sixth Amendment to the U.S. Constitution entitles a criminal defendant to more than mere legal representation. An accused has the right to effective counsel. In Strickland v. Washington, which involved 3 capital murder charges, the Supreme Court explained that to satisfy the requirements of the Sixth Amendment, counsel has a duty to make a reasonable investigation or to make a reasonable decision that makes particular investigations unnecessary. Capital cases are fundamentally different than any other criminal case, not only in the severity of the potential penalty, but in the nature of the evidence and information which must be developed and, where appropriate, confronted and challenged by both parties. This is a legitimate reason to delay the preliminary hearing. They haven't had a chance to do that yet. Receipt of discovery is not enough. The defense has to have an opportunity to consult with necessary experts. Neither defense counsel nor their experts can discharge their obligations to the client without full and complete discovery of all information underlying any forensic analysis. For instance, at the March 12th meeting, the state indicated it intended to introduce the autopsy report into evidence without any supporting expert testimony by a person, so as hearsay. The autopsy report, completed in September 16th, was not produced to the defense until November 13th. The autopsy photographs, taken on September 10th, were not produced to the defense until March 18th, not that long ago. With the reports and photographs, the defense is now in a position to provide an independent pathologist with some of the discovery tools necessary to conduct an independent evaluation of the autopsy, but it's anticipated that in the course of that evaluation, the expert will identify, the defense expert, will identify additional information that will need to be requested from the state. For example, competent forensic pathologists typically request that tissue samples be prepared and examined as part of a thorough forensic autopsy. Now, of course, in this case, a lot of this is kind of theoretical. I mean, there's no ambiguity about what caused the death of Charlie Kirk, but nevertheless, these are the technical arguments. Even more substantial discovery exists with respect to the DNA and the ballistics report that the state has indicated it intends to offer at the preliminary hearing without any supporting expert testimony. So again, they just want to submit the written report without human testimony, so as hearsay. And frankly, the DNA is to me more interesting even than the unable to match the bullet with the rifle, click headline content here. The DNA report, produced to date by the FBI and ATF, both agencies recovered minute quantities of DNA on various items, which the reports opine consist of mixtures of up to 5 or more individuals. So tiny quantities of DNA, and it's a mixture of multiple people. And they used because they had so little DNA and because of the complications caused by the mixture, they used a technique called STR mix. STR mix is a relatively novel and not, the defense will argue, not yet sufficiently robust forensics DNA analysis tool to allow it to be relied upon in a trial. They say courts have excluded STR mix and similar genotyping software analysis when appropriate validation and use of reliable procedures have not been demonstrated. So, sometimes technical analysis is excluded from evidence if the court considers it unreliable. Now, they cite a number of courts that have come to that conclusion with STR mix. Of course, they came to that conclusion based on the particular facts of the case, like maybe the STR mix wasn't done appropriately. We don't know if there's any reason to believe that happened here. Also, interestingly, they're not able to cite any courts that came to this conclusion, excluded STR mix, either in Utah or in the federal 10th district, in which Utah is. So all these courts they cite are from other states or other districts. So they cite one from the 9th Circuit, Utah's in the 10th Circuit. They cite one from the Southern District of California, a federal court. Again, that's California and a different federal district. Northern District of California, that's California and a different federal district. Eastern District of New York, again, California, New York and a different federal district. But nevertheless, to the extent it can be argued that the DNA methodology is not sufficiently robust, that would be something that leaves that DNA evidence open to attack by the defense. Now, there are standard methodologies used by courts to determine whether some form of scientific evidence should be admitted, whether it's deemed to be sufficiently reliable to be admitted as evidence. The old method was called the Fry method, and it relied on whether something was generally accepted in the scientific community. It was usually only applied to novel methods, which this would be, arguably, relatively novel method. More recently, since like the 1990s, the federal courts and most states have switched over from Fry to what they call a Daubert standard. You would have a Daubert hearing. And this is more complex than looking at just whether something is generally accepted. They look at whether it's how thoroughly it's been tested, whether there's peer review, what the error rate is, in addition to generally accepted practice. So one of the concerns with the older Fry standard was the belief that a lot of fake science was being admitted into courts in front of juries. And juries aren't technical people, so they're easily misled by fake science that sounds technical and sophisticated. So to avoid that problem, we made the admittance of scientific testimony more rigorous with the Daubert standard. Utah kind of splits the difference. They have their own standard. It's more rigorous than Fry, but less rigorous than Daubert. It's actually an interesting question. I would have to ask my buddy, attorney Steve Gosney, who's an expert on death penalty cases. Of course, once you have a death penalty case, federal law, U.S. constitutional factors come into play too. If this were in federal court, Daubert would apply. The more rigorous review of the scientific findings would apply, the scientific evidence you want to admit. I'm not sure if that would carry over into state court if they want to protect a state conviction on a capital sentence from federal appeal. Would be an interesting question. All right, so that's the DNA stuff. Let's see, got a super chat here. Just a Christian girl, $5 says, the rifle won't be ruled out because it has his DNA. The Mauser model rifle has several types of ammunition, therefore the bullet can't be ruled out. I'm not sure what you mean by that. I'm going to save this comment up here because I want to circle back to it after we talk about the bullet issue, which we'll do right now. Let me pull this up. Let's see. Where's the bullet? Okay, here we go. Regarding the firearm evidence, the defense has been provided with an ATF summary report, so not the detailed report, which they will definitely want to provide to their own defense expert, which indicates the ATF was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. So this is what gave us the clickbait headline that the bullet didn't match. Now, what's important to understand here is that when the bullet struck Charlie Kirk, it stayed largely or entirely within his body. There's no meaningful exit wound. But as is very common, especially with high-powered rifle bullets, it fragmented in the body. So the jacket is stripped off. The construction of the bullet, when I mean the bullet, a round is the entire cartridge. The brass case, the bullet, the powder, the primer. When you fire that round, what comes out of the barrel is just the bullet. Everything else stays in the gun, or in a semi-automatic would be ejected from the gun. But what enters the human body is just the pointy end, the bullet, which tends to have a lead core and commonly a copper jacket, which is, I expect with this round, this 30-06 round, how the bullet was constructed. It's not uncommon when the bullet hits a human body that the copper jacket is stripped off. It's like a jacket. It's like a skin. It's stripped off the lead core and then fragments into a bunch of little tiny pieces. And it's the copper jacket that engages the rifling inside the barrel. So if you wanted to look at the rifling of the barrel, the lands and grooves inside the barrel, and try to match them up to rifling marks on the bullet, you need a jacket that's intact because that's where you would find the marks of the lands and grooves of the rifling on the bullet is on the copper jacket. If the copper jacket fragments, it's very difficult then. It's, the smaller the pieces, the harder it is to try to match up the bullet as having been fired from that gun. Now, I mentioned earlier that this kinds of ballistics matching is loaded with fake science, and there is a lot of that. On the extreme ends, it's you can get fairly definite findings, especially in terms of exclusion. Now, not every rifle has the same number or twist rate of lands and grooves of rifling. So say a rifle had, I'll just say 6 lands and grooves, and you recover an intact bullet, and the bullet has clearly distinguishable rifle markings of 7 lands and grooves. Well, that bullet was definitely not fired out of that rifle. You can exclude it with certainty. Or if the bullet's a different caliber than the rifle, if this was a 5.56 bullet found in Charlie Kirk's body and the rifle is 30-06, that 30-06 rifle did not fire that 5.56 bullet. You can have a definite exclusion if you have this kind of gross disconnects, mismatches between the round and the bullet. If you have the same caliber and the same number of lands and grooves, kind of the gross markings that would be made, then these ballistics matching places try to identify that then the bullet could have been fired from the gun, right? It's possible. It's not excluded. And then they try to make a definite match by looking at microscopic characteristics of little tiny scratches. There's imperfections in the chambers when a a bullet is loaded into a gun, there's imperfections in the rifling, and they try to make claims that these particular imperfections we found on the bullet match up exactly with the imperfections we found in the chamber and in the barrel. We can make an absolute identification. A lot of that has always been fake science because we don't really know if another gun could have had similar, of the same caliber, same lands and grooves, same gross characteristics, could have had similar characteristics that would have left similar markings. So it's very difficult, really, to say honestly that this is, with a high degree of certainty, a match with that rifle. That rifle definitely fired this bullet. Very, very sketchy, to say the least. You can definitely say it's consistent with, if you have that data, but it's very sketchy to say, I know for certainty that this rifle fired that bullet based on the ballistic markings on the round. Someone mentioned this in a super chat, I think, but it's even worse today than it used to be. Because today, so many firearms, and this would not necessarily apply to this Mauser rifle. Mauser rifles tend to be old manufacturing rifles made with old technology. But modern rifles are largely produced with very well-controlled tolerances, CNC machinery, computer numerically controlled machinery. It's like a robot. It turns out one barrel, it turns out 1,000 barrels. They're all the same. They're all exactly the same. There's no, or at least not much, variation in tool marks. So you take one Glock 17 pistol, and then you take another Glock 17 pistol, you fire 2 bullets out of them, it's going to leave essentially the same markings. And there's a lot of Glock 17 pistols out there. So modern manufacturing techniques with their much more consistent tolerances make it even more difficult to be able to make a claim that this particular gun fired that particular bullet. Now, here, the ATF is not saying this rifle did not fire this bullet. They're not saying that. They're just saying because the bullet was so fragmented, we simply can't determine if there's a match between what's left of this fragmented bullet and that particular rifle. That doesn't mean the rifle didn't fire the bullet. I mean, we know the bullet's the same caliber, so that would be consistent. But there's not enough data from which we can make either say it's a match or make a definite connection between the rifle and the bullet. The state has not indicated an intent to produce this report at the preliminary hearing, but the defense may very well decide to offer the testimony of the ATF firearms analyst as exculpatory evidence at the preliminary hearing. To make that determination, whether we want to do that, it's necessary for the defense and its experts to review the ATF case file and protocols relating to this examination, which have not yet been provided. The state has also indicated the FBI is in the process of conducting a second comparative bullet analysis, as well as a bullet lead analysis, but these analyses are not yet complete. So I talked about matching the bullet based on gross characteristics like the lands and grooves. But another way you can try to match things up is by doing probably a spectrographic analysis of the lead core of the bullet. The lead used in bullets comes in a variety of different alloys. Some are harder, some are softer. So it's never pure lead. It's lead alloyed with other metals, and that varies. So you could get the specific composition of the lead core of the bullet, which they have, and then test for that identical lead composition inside the rifle. That wouldn't definitely determine the rifle fired the bullet, but it would be another match between rifle and bullet. Continuing here, again, until the defense receives the case files and protocols relating to these analyses and has them independently evaluated by the expert, they will not be in a position to assess the reliability of the evidence if either the state or the defense decides to proffer it. Importantly, in a capital case, the state cannot, consistent with federal due process, I touched on that earlier, federal due process and the Fourth and Eighth Amendments and separation of powers principles, a state cannot declare that hearsay reports used as the basis to justify the continued detention of a suspect pre-trial are entitled to an irrebuttable presumption of reliability that neither the defense nor the magistrate can challenge. And a lot of this now, I think, is just due process stuff. So I'm going to skip over it for now. Yeah, there's the conclusion. The rest of this document is a lengthy addendum. Just a Christian girl. Right. So the rifle won't be ruled out because it has his DNA. The Mauser model rifle has several types of ammunition. Therefore, the bullet can't be ruled out. It's important to keep in mind that you don't even need the rifle. You don't need the rifle. You don't need the bullet to be able to convict of murder if there's sufficient other evidence to convict beyond a reasonable doubt. The weapon and the bullet are not requirements to a conviction. I mean, this becomes apparent. Obviously, they're nice to have for the state, right? If everything matches up. They're nice to have for the defense if things don't match up, right? If it's a different caliber or the weapon could be excluded, you'd like to be able to say that. But imagine that, two men are on sailboats, right? Each on their own sailboats. Not far off a pier. There's 1,000 witnesses on the pier to what's about to happen. There's cameras. There's lots of stuff. But their two men they're standing on their own sailboats. And one of them shoots the other unlawfully, murders him. But the bullet passes completely through and ends up somewhere in the ocean, can't be recovered. And then the shooter takes his gun and throws that into the ocean, so it can't be recovered. So the state doesn't have the bullet and doesn't have the pistol. In that scenario, you can still prove guilt beyond a reasonable doubt. You don't need the gun or the pistol for that. Obviously, the more evidence the state can present to a jury, consistent with their narrative of guilt that Tyler Robinson assassinated Charlie Kirk, the easier it is for them to get to their required threshold of proving guilt beyond a reasonable doubt. Let's see. Reven says here, in regard to the 30-06, not all bullets are the same weight. It comes in different weights. It also has a very light variation, and the light variation goes out at an unusually high velocity for a 30-06 round and totally fragments in tissue. Another thing I wanted to mention is one of the some of these conspiracy theory things that are out there. One of which is that a 30-06 fired into a human neck, the round will simply not stay in the body. It's a high-powered rifle. It's a very high-powered rifle. It's a 1,000-yard man-killing round. And if you shoot someone in the neck with it, the bullet's going to go clear through. And the fact that they recovered the bullet inside Charlie Kirk's body indicates there's something going on here. There's shenanigans happening. The story we're being told can't be true. This story of Tyler Robinson firing a 30-06 round with that rifle into Charlie Kirk's neck has to be a fabrication. But bullets do weird things when they hit things. And that's a field called terminal ballistics, when they impact a target, an object. They do weird things. They're very hard to predict. It's more a matter of probability than any kind of certainty. Now, if I fired a 30-06 round into a man's neck, the probability is the round will go clear through. That's what I would expect to happen. But it doesn't always happen. Bullets can hit a human body and turn 90 degrees. And the human body is very varied in terms of its constituency and characteristics of different tissues and organs. It's not like firing into a homogeneous block of gelatin, ballistic gelatin, for example. You've probably seen people do that on YouTube. You get a clear block of gelatin, you fire a bullet into it, it creates a cavity and path through the gelatin. It's always fun to look at. But human bodies are not that. The gelatin is supposed to be a rough approximation of human tissue, but human tissues come in all different forms. There's bones are a tissue, right? Flesh is a tissue. Muscle is a tissue. The organs are tissue. Some organs are rather porous, like lungs, very soft. Some organs are very elastic. Some organs are like the spleen is very inelastic. It has a tendency to rupture. And bones come in different, obviously, sizes, different densities. Density can change with age. So there's lots of complicated stuff that can happen with a bullet. I can tell you, just historically speaking, Martin Luther King Jr. was assassinated with a 30-06 bullet, and it stayed in his body. There was not an exit wound. Now, he got shot in the face, and it came at his chin, and it went into his torso. He was shot from an elevated position, so there's lots of complexities there, but the complexities are not uncommon. In the case of Charlie Kirk, I believe there's evidence that the bullet actually struck his spine, which is one of the hardest bones in the body. And also, it's important to keep in mind that the neck is pretty elastic, right? You'd think it would have to be, right? Because the way we turn our head, right? The neck's not rigid. And you wouldn't see it. You might see it on video if you could go frame by frame. But when you shoot a bullet into ballistic gelatin, one of the things you see is you'll see a big temporary cavity form if you watch it on a high-speed camera. As the bullet enters, the energy from the bullet is transferred into the gelatin, and you'll often see a big temporary cavity form, and then it collapses as the bullet passes. Well, that happens in the human body too, in particular types of tissue. And what that cavity is doing is it's absorbing energy. The kinetic energy of the bullet is being transferred into energy within the gelatin block, and the same thing happens in a human body. You can see this in where you can break down video of humans who are shot. It's not unusual for them to be shot in a part of the body, and that part of the body to expand like ballistic gelatin and then instantly collapse back down as the energy of the bullet is consumed, and then the bullet has a greater tendency to remain in the body. You would think this is crazy, but human skin can stop a bullet. This happens a lot. If you've ever hunted like medium-sized game, like a deer, it's not, or an elk or something like that, it's not unusual for the bullet to strike the animal, pierce the skin on the entry wound, pass through muscle, tissue, other stuff, get to the other side of the animal, the underside of the skin on the other side of the animal, and the skin catches the bullet because the skin is elastic and the bullet's energy is mostly depleted by that point. It's not uncommon to find a bullet you fired into an animal just under the skin on the other side of the animal. And by the way, some of you may think I told you about Martin Luther King Jr. You may think, well, that's like JFK, right? There's lots of conspiracy theories around his assassination too. But you can just Google or Grok. I mean, just before I started the show, I asked, in fact, I'll pull it up. I'll share this with all of you. You don't have to take my word for it. Let's see, that's not what I want. I want... Hold on a second. I'm going to do it this way. Let me pull up the thumbnail first, and then I'll do this. All right, so I did this just before I started the show. One of the reasons I was a little late. Find for me, I asked Grok, with links to original sources, articles in legitimate medical literature describing instances of high-power rifle bullets being fired into human beings with the bullet being retained in the body and not causing an exit wound. And then I added, do not fabricate sources, because sometimes AI will lie to you to try to make you happy. But here's one. AK-47, rifle gunshot to the face, high-power assault rifle bullet retained in the neck. And that's this example. It says, atypical gunshot injury to the right side of the face with the bullet lodged in the carotid sheath. A case report. I believe this woman survived. 27-year-old African woman. Of course, lots of AK-47s in Africa. Received a inadvertent AK-47 rifle gunshot injury to the right side of her face, a large ragged entry wound, and no exit wound. Oh, here we go. So you can see it. Inadvertent AK-47 shotgun to the face, large ragged entry wound, no exit wound. The bullet remained in her body. Another example here. The case, and I'll read you the summary and then I'll show you that it's real. A 13-year-old girl presented 10 days after a high-velocity rifle gunshot to the upper quadrant of the abdomen, small penetrating entry wound, no exit wound. Now, they ridiculously refer to this as a 30 millimeter rifle cartridge, which would have blown her body in part. I'm sure what they meant was a 30 caliber rifle cartridge. That's consistent with the velocity here too. You know, doctors don't know. Doctors don't know anything about ballistics. But here's the actual article. Retained intra-abdominal rifle cartridge in a pediatric patient. That's a child that was shot, 13-year-old. Here's another example. AK-47 rifle gunshot to the thoracic spine. Combat-related gunshot to the back with no exit wound. Bullet was retained in the spinal canal. Here's another example, M16. That would be a 5.56 round, high muzzle energy 5.56 bullet after passing through vehicle armor. So that would have consumed a lot of its energy. It's not a great example there, but those are several, and there's more. There's scores of these if you go through the literature. So the fact that the bullet didn't come out does not definitively mean anything. I mean, it's an unlikely event. It's not what I would anticipate happening. But I've hunted, and I've read more medical examiner reports and forensics reports than you could possibly imagine over 35 years of doing use of force law. And I've seen many cases in which a bullet will enter a body, turn 90 degrees, enter a neck, go straight down through the body. Bullets just do weird things when they hit targets, especially dense targets. You just never really know where that round is going to go. All right, let's see. Got a couple super chats here. $2. Thank you very much, Sassfras. I appreciate that. Justin Wright, member for 6 months. Do we know what the bullet even is? If you're standard deer hunting soft point, then I can totally see this scenario. I don't know what it is. And 3006 in particular comes in a huge variety because it's used for high-level competitive shooting. You have a very specific bullet for that. It's used for hunting where you typically have a jacketed but soft point, exposed lead at the tip to facilitate mushrooming. You'll have more modern variations in which there's an actual cavity in the point of the bullets. Lots and lots of variations. I haven't seen a report specifically on what they found here. Sastra says, do you believe they can find an unbiased jury? Yeah, they're going to find a jury, and the jury's going to tell them they're unbiased. How do you really know? Citizen, $10. I've always been fascinated with forensics. It is fascinating. It's one of the dangers of forensics. It's so fascinating, and people watch CSI. They hear about DNA matches, and they often give forensics types evidence a weight that it doesn't really deserve. Unfortunately, let's see. Yep. And Justin Wright, $5. Remember, Grosskreutz from the Rittenhouse trial, his bicep aerosolized. Yeah, it just disintegrated. That 5.56 round fired by Rittenhouse. And that was just a ball round of 5.56. 5.56 in particular is very interesting because almost by design, it tumbles. I think it is by design. It tumbles when it hits. When it was first introduced in Vietnam in small numbers, the round was fired at a comparatively low velocity from where it ended up. And the lower the velocity, the less stable the round. Later, they would increase the velocity because the military likes to be able to shoot at long distances, 600 yards, 1,000 yards. And because a low-velocity bullet has a higher arc and is inherently less stable, it tends to be less accurate at distance. So they made the bullet go faster, ultimately, which stabilizes the bullet, makes it less likely to tumble. But when it was originally introduced in Vietnam in small numbers at a lower velocity, it would tumble horrifically and cause horrific injuries in anybody it struck. And those soldiers loved it. It did absolutely catastrophic damage to the enemy when it hit. When they sped up the round, it became very stable, which was good for long-distance shooting. But in Mogadishu, for example, in the 1990s, our guys were shooting Somalians, attacking them, and those highly stable 5.56 bullets were not tumbling at all. They were drilling neat little holes through people, like pencil diameter holes through people. And those holes may well have been mortal injuries, but they were not killing the bad guys right then. And the bad guys were able to continue fighting for a considerable period of time. So yeah, terminal ballistics is a very interesting subject for sure. Weird things happen. No question about that. Let's see. Did I have anything else? I didn't mean to go this long. An hour and 40 minutes on this show. It's really gonna tighten up. I have a hard deadline today. I got some meetings I have to get to. So I'm still gonna do the members show. We're gonna transition from this to the members show. I'm just gonna have to tighten it up a little bit, I think. Somebody said Bondi's gone. Is that true? I'll take a quick look for everybody. There's reports, there's rumors. There's rumors. Trump is finally here. I'll pull it up. I'll share it with all of you. We can look at it together. Here we go. All right. NBC News reporting President Trump's grown increasingly frustrated with Bondi, is considering firing her. Dasha Byrne says a person familiar with the situation tells me Pam Bondi will be out as AG imminently. Polymarket says Trump has reportedly informed Pam Bondi that her time as Attorney General is nearing its end. Kobisi letter, President Trump is, so same thing. Let's see. CNN reporting President Trump has privately discussed firing Pam Bondi and replacing her with EPA Administrator Lee Zeldin. Trump responded, telling Fox News Attorney General Pam Bondi is a wonderful person, is doing a good job. All right, well, I don't know that she's doing a good job, but he's the boss. All right, so far it's just rumors. It's just rumors. Not that it wouldn't be deserved, by the way. I've not been overly impressed with Pam Bondi. I respect the challenges she has, but nevertheless, less has been happening than I would have liked to have seen, and there's been a variety of missteps that seemed to me like they were unnecessary, didn't have to happen. Like the stupid Epstein books they came out with early on. Remember those? All right, let me think. Is there anything else? Let me look at law of self-defense here. Jack says, I read a case where they could not find the actual weapon, but found a couple that were manufactured right before and after and did a ballistic match against the bullet, claiming a match. Would that discredit ballistic testing? That doesn't sound to me to be who did that, the state? Because if I were the defense, I would say you just proved that a different rifle could have done it. Right? 1,000 of these rifles, 100,000 of these rifles were made. Any one of them could have fired this bullet because even when it's not the exact rifle, the others match anyway. That's interesting. Stephen says bullet matching and case matching have been pretty much a lie for many decades, as previously brought up about modern machining. Yep. Stephen says testing can rule out bullets in cases, but very seldom can they definitely do a match. I agree. Stephen says, Andrew, question about jury selection in death penalty cases. How can citizens who oppose the death penalty be filtered out? That's packing the jury right there and getting a non-representative sample of the population. Listen, full disclosure, I've never worked a death penalty case, so I'm going to defer on those technical questions to my buddy Steve Gosney. I'll get Steve to come on the show. Maybe tomorrow. I'll see if he's available. He's a nationally recognized expert on death penalty matters. Jack says, I've read that Kirk was wearing body armor and the bullet may have ricocheted off it before impacting his neck. That can definitely happen. I don't know about the body armor question. There's variations in body armor. There's soft body armor, which is, kind of a flexible, heavy clothing. You can think of it as. And then there's body armor that has plates in it, either metal or ceramic plates. Generally speaking, soft body armor can be effective at stopping pistol rounds, 9mm, 45 ACP, that kind of stuff. which has a small fraction of the power of a 3006. Generally speaking, I would expect, the unexpected can happen, as we talked about. I would expect a high-power rifle round like a 3006 to go through soft body armor like it's not even there, effortlessly. But if Charlie Kirk was wearing body armor with steel or a ceramic plate, that's designed to stop even high-powered body armor. Now, one thing that can happen is a round can hit body armor, a plate, and ricochet off the plate, like up through the bottom of the chin. That's not great. But I don't know details about what he was wearing. Let's see. All right, I just want to make sure I'm not missing anybody here. Let me take a look. I do have a Rumble rant I'll share. It's really for the next show. In fact, let me pull. The next show is going to be this. Talking about NATO being finished. Looking at X, looking at Rumble, and we're all caught up here. All right. So, folks, we're going to transition now over to the menu, members only channel. Mike's in Miami says, a Rumble rant. Let me pull this up real quick because some of you may have this question. He says, if I join via Rumble, how can I attend your YouTube members only? The missus love you, but not spending money. I don't know how to do members only on Rumble. Rumble is a very weird platform. So you do it on YouTube, or you can be a member on Locals. The link for the local show is in the description. The way Rumble does memberships is very weird. It's like you're not a member of my channel. You have to become a member of Rumble. And then I have to deliver my content on Rumble in a much more complicated way. And I don't want to learn how to do that. So I would encourage you, if you don't want to give YouTube money, which I certainly understand, but you'd like to access the members only content, I would encourage you to become a member on Locals. We do stream the membership content to Locals. All right, let me pull up the NATO and get that. Get that going. Let's see. I'll start the members only stream for NATO right away. Whoop, I want to pull down that banner. Pull down the banner. And I'm launching the members only show covering the ending of American participation in NATO being threatened by Trump. That is going live right now. The links for the show, the links on Locals and for members on YouTube are in the description. So I look forward to seeing all of you joining me over there as that's going live, even as we speak. And my notification about that has just gone out. So I look forward to seeing all of you there. Until we meet up there again, I expect to be back after, tomorrow, of course, 11 a.m. or thereabouts Eastern time for our normal scheduled show. Hopefully you'll join us for the NATO show as a member. And until we meet up again, one way or... Jeff Smith, member for 4 months, says, you and Ricada are the best streaming lawyers. That's very kind of you. And Jack Wade, $5. Just $5. Just generosity. That's very, very nice. I did have a Rumble rant from Jonathan, who paid $5, so I want to give him credit. It really involves the NATO show. But he says, you may not know this. Biden made it law that to leave or defund NATO, a president now needs 2/3 approval from the Senate. There are 10 Republican neocons in the Senate, so good luck. You won't get the 2/3. But I'm not sure that statute is constitutionally valid. I don't think it is. So I don't think it's the barrier that it's made out to be. But we'll talk about that in the members only show. Until we meet up again, I remain attorney Andrew Branca for The Branca Show. Stay safe.